inaugural plenary session of the Corporate and Commercial Law Conference 2018, which has been arranged by Think Legal. Before proceeding to the plenary session, I think it is required that I should make some introductory remarks about Think Legal, and then why do we think that having this conference is a good idea. Think Legal is essentially an online legal portal where various materials which are of interest to lawyers, articles, case reports, so on and so forth, are uploaded and are available to the public. In addition, over the past 1.5 years or so, Think Legal has organized a series of lectures, 7 so far, where judges of the Supreme Court of Bangladesh, current as well as retired, have given speeches on all manner of subject matters concerning the law. These speeches, these lectures have been taped, they have been uploaded and are available in the social media, and they are already proving to be a useful resource, points of reference for those who are interested to do research in the law. However, at Think Legal, we thought that it was necessary that we should graduate to a different level. Now, today's conference. The subject matter of today's conference is very wide, corporate and commercial, but I'm sure all of you can imagine what this conference is about. The legal environment of doing business in Bangladesh is a matter which concerns all of us. Bangladesh has made great strides in development. We are graduating into the ranks of a developing country. If we are to establish ourselves as a developing country, then it is very important for us to ensure that the legal environment for doing business is understood, is prepared to be dynamic in terms of reforming itself, in terms of being responsive to the needs of its users. From the point of view of the legal profession, we feel that there has been some paucity in organizing forums where stakeholders in the legal environment of Bangladesh have an opportunity to ventilate their views. It is this need that we want to fulfill. We are sure that there are other organizations, mostly chambers of commerce and industry, which have had similar endeavors, but I believe that it is about time that the perspective of those who are engaged in the practice of law in Bangladesh are shared with the people at large. And also, as I said, the stakeholders, the users of our legal system also have an opportunity to ventilate their views and to give their input. This is a first endeavor. There has not been a similar endeavor of its kind, certainly from the point of view of the lawyers. We are sure that by the end of the day, there will be a lot of critical comment about the way in which this program has been organized. But we look forward to such critical comment because I believe that such constructive criticism will hold us in good stead as we seek to develop forward, and I'm sure that the next conference is going to be even better. Now, the way in which the conference has been organized. There is a plenary session today, and as you can already see that we have a very distinguished panel here of 3, and I will also try to make up the numbers. Mr. Syed Nasim Manzur of the Apex Group, Mr. Rumee, who is a former Deputy Governor of the Bangladesh Bank and who was the first Bangladeshi Chief Executive of a multinational bank in Bangladesh, and Mr. Asif Ibrahim, who was President of the Dhaka Chamber of Commerce and Industry. These gentlemen need no introduction, and today we want to keep a tight schedule, so I will not bore you with platitudes over here. In the plenary session, a keynote presentation will also be placed by a speaker whom I know personally very well and about whom I'm going to say a bit later. But before that, the plenary session, which is going to last until 11 a.m., there will be a keynote speech. After the keynote speech, we hope will set the context of a discussion about the legal environment of doing business in Bangladesh, where we would be very grateful for the words of wisdom from our panelists. We will also invite participants to pose their questions, and by the end of it, hopefully we will have some material which later on, at the end of the conference, we will be able to collate and make available in the social media. After the plenary session ends, there is going to be a coffee break. This coffee break is very important. I know that it will give an opportunity for the young lawyers to take a lot of selfies, but I hope they will also use it as an opportunity for self-improvement. And then, after the coffee break ends, during the course of the day, interspersed by a break of lunch and a further coffee break, there are going to be 7 breakout sessions where we are going to divide ourselves into smaller groups. I understand that the room will be partitioned into 3 parts, and where individual topics which are of interest as far as the legal environment for doing business in Bangladesh will be spoken about. Keynote speech will be given, panelists will be there, and comments will be made, participants will pose their question. And we will end with a speech by a very distinguished judge of the Honorable Appellate Division of the Supreme Court of Bangladesh, my Lord Mr. Justice Iman Ali. Now to the speaker. The presenter of the keynote speaker is Ms. Christabel Randolph, who is presently the legal head of Marico Bangladesh Limited. Before that, following a very distinguished academic career, she worked at Dr. Kamal Hussain and Associates, and after having finished at Dr. Kamal Hussain and Associates, she joined British American Tobacco. And I personally have had an opportunity to work with her while representing British American Tobacco and Marico Bangladesh in litigation in the Supreme Court of Bangladesh. Christabel Randolph, to a very large extent, Ms. Christabel Randolph represents what this conference is all about and what this conference wants to achieve. Ms. Christabel Randolph, during the course of her work, has already accumulated much wisdom about doing business in Bangladesh from the perspective of 2 foreign investors. She has faced the pitfalls of doing Bangladesh. She also knows of the prospects of doing business in Bangladesh. What we at Think Legal want is that persons like Christabel Randolph, and there are many others who are working in other multinationals. Next to Christabel Randolph, there is Ms. Karishma Jahan, who is presently head of legal at Summit. The various telecommunication companies in Bangladesh also have their in-house legal persons. So one of the objectives of this sort of conference is to have persons who have, over the past 5 or 10 years, accumulated wisdom about doing business in Bangladesh, in our legal environment, will have an opportunity to share their experiences. And hopefully today, perhaps one of the, I do not know, I'm not sure how many persons from government and how many persons from politics are here. But I believe as we move forward, these people should also, these persons from government, persons who make policies, they should also be invited so that they can participate and they can also listen to us. So without further ado, I take great pride and pleasure in introducing to you Ms. Christabel Randolph, Head of Legal at Marico Bangladesh Limited, and would request her to make her keynote presentation. Thank you very much.
Thank you, Mustafizur, for the very generous introduction. Honorable Justices of the Supreme Court of Bangladesh, learned members of the Bar, distinguished guests and panelists, ladies and gentlemen, a very good morning to you all. I have been tasked with presenting the keynote of this session on doing business in Bangladesh, which aims to sketch the legal and regulatory environment impacting businesses. I hope this sketch is able to draw out sharper insights from our panelists and also set the tone for the deliberations of the day. Before I go into the legal and regulatory environment, I would just take a few minutes to talk about how Bangladesh is a success story. We have been called a development paradox and also the new Asian tiger. On macroeconomic parameters, we have graduated from a least developed country status to a developing country status with a per capita income of $1,600. We have had a consistent GDP growth of more than 6% over the last 5 years. Poverty has been halved and stands at 24%. We have a high foreign currency reserve of 32 billion. 80% of our export earnings come from the RMG sector, and what is even more significant is that this sector has been the sole driving force of female employment and female empowerment in Bangladesh. For the first time, we are in the top 100 of the global competitiveness ranking by the World Economic Forum. We are projected to be one of the top 3 fastest growing economies by 2050. Our digital and technology transformation has also contributed to where we are today. We have over 143 million mobile users and 80 million internet clients. Bangladesh adults have carried out 34% transactions over digital mediums as opposed to a South Asian average of 27%. We have had significant financial inclusion led by mobile financial services. On the infrastructure front, we have had significant strides. We have 40 power plants with an installed capacity of more than 16,000 megawatts. We now have a 4-lane Dhaka-Chittagong highway, a 3rd seaport at Paira. Our Podda Bridge is 50% complete. We have a lot to be proud of and hopeful for. From industries in the consumer business to telecom to technology, Bangladesh holds huge potential and prospects. To unlock this potential, what has consistently been identified as priorities are increased private investment, healthy capital markets, sustainable revenue generation, and a shift in our workforce skills. Yet, on World Bank's Doing Ease of Business in Bangladesh, we have actually slipped down a notch. The Doing Business reports have now become a guiding indicator of what the legal and regulatory environment is in a particular country. Bangladesh is ranked 177th out of 190 countries. It takes more than a year to get a utility connection, almost a year to register property in Bangladesh, which is actually double the South Asian average, and almost 4 years to enforce a contract at the court of first instance, which is for us the district courts. And the cost of that enforcement is 66% of the contract value. So while we have a bright future to look forward to, I will illustrate the state of regulatory affairs with a very few basic examples of the difficulties businesses face in their day-to-day operations. Example 1. A company which has foreign shareholders as shareholder directors often need to transfer the shares when one such foreign national is exiting the company or leaving the country. The Registrar of Joint Stock Companies, which is responsible for effecting and registering the share transfers, now require personal attendance of the transferor, which is a fair requirement to curb fraud, to curb fraudulent transfers. However, in cases where an individual has already left Bangladesh, they have been unwilling as well as reluctant to accept transfer documents authenticated by the consulates abroad. As a result, I am aware of companies where dividend remittances, critical transactions with banks, royalty repatriation, dividend repatriation has been held up for almost 2 years, simply because the RJSC, which is the primary regulator for registering share transfers, does not appreciate the documentation requirements and also insists on physical presence of the transferors in cases where the national is non-Bangladeshi. This in itself is enough to discourage foreign investors for whom appointing foreign nationals, transferring shares is a very common thing. As many of you would know, that there is a licensing scheme operated by our national standards body, which is the Bangladesh Standards and Testing Institution. This licensing scheme is mandatory for 154 products, of which there are consumer products like toilet soap, shampoos, edible oils, as well as electronic, textiles, and jute products. It is also mandatory for products imported into Bangladesh, including milk powder, chips, crackers, and toffees, just to name a few. The licensing scheme operated by the Bangladesh Standards and Testing Institution is intended to ensure quality for the products being sold in the domestic market of Bangladesh. I would like to tell you the story of a renowned chocolate and confectionery manufacturer that has shied away from investing in Bangladesh when it realized that the national quality standards were below its global product standards. The manufacturer made a request to the BSTI to review its national standards and align it with comparable global standards or comparable standards of other countries in South Asia or the Asia Pacific region. This request was met with great reluctance and hesitation, and finally the request was not entertained. This quality standard alone was the barrier which dissuaded investment in Bangladesh by the global manufacturer. In a number of other cases, manufacturers of fast-moving consumer goods were discouraged and in fact actively hindered from introducing new category of products in Bangladesh simply because our standards institution refused to frame product standards and rather termed those products as unsafe for the Bangladesh market, even though they are being sold globally and marketed in many other countries, including Western markets as well as other Asian countries. I cite these examples on a no-name basis for obvious reasons. This form of regulatory discretion is not only preventing innovation and technology transfer, but this will also prejudice Bangladeshi manufacturers trying to tap export markets because of the lack of reciprocity or comparable licensing quality regimes. In a country with a population of 160 million people, we are looking at 160 million consumers and a large potential for technology transfer, improving our consumer goods production sector, which is being untapped simply because of regulatory reluctance and in often cases capability issue on terms of knowledge management. The third example involves a global business process outsourcing and consultancy firm which had to wind up its business in Bangladesh simply because our labor law regime is not familiar with outsourcing. If we look at the examples of India, in Hyderabad and Bangalore, where business process outsourcing has been one of the key drivers of development, Bangladesh needs to look at the fourth industrial revolution, transform its workforce skills, and what we need is a regulatory environment at the very basic, feasible employment environment which will take account of this outsourcing regime and facilitate our strides in the service industry. What we are looking at is inconsistency, lack of certainty, and lack of clarity. Just last year, there was a confusion of whether 60 services provided by our port authorities during import and export clearances were VATable services or not. There was conflicting views issued by the National Board of Revenue as well as the Chittagong Port Authority. In Bangladesh, prices are regulated through a price approval mechanism under our Value Added Tax Act. The higher judiciary has witnessed large number of litigation on account of price approval cases. The price approval cases often see the revenue authorities revising prices of manufacturers upwards even without any consistent principle or accounting basis. Another dangerous pattern of revenue collection that has emerged is retrospective imposition of value-added tax and VAT in cases where there was no revenue fraud committed, with particular targeting of cases involving multinational companies. As we all know, the telecom industry has seen most of such nuances on both the vatability and licensing front. The transfer pricing regulations were introduced in Bangladesh in 2012, and in 2019, the transfer pricing audits are about to commence by the tax authorities. These are meant to apply to all related party transactions or associated enterprises, but the tax authorities have already indicated that MNCs would be under the lens, as they believe there are enough scope for collecting more taxes from MNCs. This actually defeats the purpose of having a level playing field and a consistent VAT and revenue framework for all businesses in Bangladesh. While there is a proclivity for regulation or higher regulatory intervention, in certain cases there is nonchalance to regulate. Take, for example, the violation of intellectual property rights. Our markets are flooded with illicit products which are both counterfeit and look-alike. Large numbers of products are smuggled into the Bangladesh market, be it consumer products, be it electronics, even pharmaceuticals. The government is losing an estimated 600 crore simply due to illicit products in the consumer goods sector. Yet, no regulator is taking ownership of the problem, and there is a lack of enforcement. There are no corporate governance regulations for private companies. The corporate governance guidelines issued by the Securities and Exchange Commission obviously applies only to public listed companies. There is no monitoring of returns filing by private enterprises. There are no disclosure requirements whatsoever, and the absence of a basic corporate governance framework has also contributed to calamities in our banking sector. The regulatory framework for e-commerce is underdeveloped, even though now companies are spending on an average 6 to 8% of their revenue in the digital market. Digital marketing, advertising, social media marketing, all of this, sale of goods through digital channels is taking over in Bangladesh. There is also no regulation of advertising in any form, and hence no check on negligent or fraudulent representations by manufacturers. A staggering 80,000 crores in non-performing loans is testimony to the corruption that underlies regulatory inconsistencies. Monetary corruption is now factored into the cost of compliance in Bangladesh. Corruption can also take the form of incompetence, where the regulator is simply unable to appreciate an issue. A small example is the issuance or renewal of import registration certificates and export registration certificates, which are processed by the Chief Controller of Import and Exports, called CCI. Concerned officers at CCIs are not familiar with the different types of corporate entities, and there have been cases where these officers have insisted that companies change all their documentation to classify them as a joint venture company simply because that is the only type of entity they are familiar with. Our revenue laws incentivize its officers to detect evasion or any other offense. This has led to an unhealthy practices of exorbitant claims or VAT demands on account of evasion or irregularities, in many cases which do not have any legal or factual basis. Under our tax, VAT and customs regime, an assessee is obliged to go through the hearing and appeal procedures under the Revenue Authority and then finally appeal to the High Court with a 10% appeal deposit. What is even more alarming that the 2012 VAT Act proposes that this appeal deposit be given in 3 stages, which would in effect amount to a 30% deposit. When we see VAT demands and revenue demands which are of exorbitant sums and which often lack any proper accounting or legal basis, it begs the question, what financial burden are we placing on businesses when we would require them to pay 30% of those demands simply to have a legal right of redress? And this brings me to the most important part of our legal framework, which is the right to redress or a proper remedy for illegal, irrational, or unreasonable acts of a regulator or even of a regulation. An independent judiciary is the bedrock of good governance and the very foundation of rule of law. While we have constitutional safeguards on right to property and right to trade, do these do enough to curb the regulatory excesses or irrationalities that we face in our day-to-day businesses? Do we have effective legal remedies under our laws and our constitutions? Are our judicial procedures sensitive to the essence of time in commercial matters? Is there perhaps a need for separate or specialized commercial courts and tax courts in Bangladesh? These are just a few questions on our judicial procedures and our legal framework that I would leave our panelists with. If we can't simplify our processes, develop capability, and improve the attitude of our regulators, and are not able to avail effective legal remedies even in courts, then we will not be able to provide the stability and certainty required for doing business in Bangladesh, and we will be depriving ourselves from unlocking our future potential that has actually termed us and labeled us as the new Asian tiger. With these very few basic and summary thoughts, I hope I've been able to sketch actually the many legal and regulatory nuances that come up in doing business in our day-to-day lives. And I leave these thoughts with our panelists and with all of you, and look forward to the insights during the sessions of the day. Thank you.
Thank you very much. Yeah. Thank you very much, Christabel. Thank you for showing both the prospects as well as the problems of doing business in Bangladesh. One of the great things about the Think Legal platform is that whatever is the output of today's conference will be preserved and will be available in the internet, in social media. And so those of you who were perhaps a bit lazy taking notes will have an opportunity to come back to Christabel's summary and as a point of reference. And if you look through it, you will see the difficulties that investors have encountered in doing business in Bangladesh. I can attest to the fact that many of her observations are borne by personal experience. Now, to the panelists. The first gentleman whom I would like to pose a very basic question, a very general question as an opener, is Mr. Muhammad Rumee Ali. Mr. Muhammad Rumee Ali is actually in a very unique because of the path his very distinguished career has taken. He has been the Chief Executive Officer of a multinational bank in Bangladesh. This was preceded by spells abroad. After that, he served as a Deputy Governor of Bangladesh Bank. And presently, he is the Chief Executive Officer of Bangladesh International Arbitration Center. So he has seen he has experienced the legal environment of Bangladesh from the perspective of one who has been governed, one who has governed, and also one who seeks to resolve disputes when governance goes wrong. So under these circumstances, the very basic question that I pose to you is by sharing a remark that I've heard from a foreign investor. It's very simple. Bangladesh is not a poor country, but it is a poorly governed country. So what are your views? Thank you very much.
Thank you very much for that question. I think we had a very good presentation of the problems that are facing, plus and also she highlighted the potential of this country, which I personally believe in, having spent, as you mentioned, on both sides of the table. The question you asked was about governance, and I personally also believe that it is governance that is at a fundamental issue. But you know, in Bangla there is a story of this young person or a student who was being, who went to the tutor, and he said that, look, learn the essay of cow, because the cow essay is likely to be asked in your exam. So he studied cow, but when he went to the exam, he found it was about the river. So what he did was he said that I took a boat and went down the river. The boat was good, the river was also nice, but I saw a cow on the shores having grass, and he started talking, and the whole essay was about the cow. So I'm a bit like that. I have got to bring it to what I represent, because I think it is one of the fundamentals of governance. You see, I believe business is, a basis of business is contracts. Whether it's a contract between an institution and the state, which is the regulatory framework, whether it's a contract between the institution and another institution, or it is a contract between the institution and an individual. Of course, there is the bigger social contract between an institution and the community. But fundamentally, these are the contracts which are there, and they are real. They are real, and you can't wish them away. So every business actually depends on these contracts. Now, if a business is, every business understands the risk of non-performance of a contract, different interpretations of a contract, violation of a contract are risks which are real and can happen to any business. So they look at, when they take an investment decision, they look at, how do I get a remedy in a situation, one of these situations? And that is, as I said, essential part of governance. And they find that in Bangladesh, that is one of the greatest problems. How do I enforce a contract? While I don't want to repeat what was said before, that we are 189 out of 190 countries, and that tells you clearly that we have a problem here. And the main problem is that in this is that it takes 4 years, more than 4 years, and it takes 66% of the value of the claim. So any banker or even a person who is in finance or business will tell you that it's not worth the time. If you are at the end of the contract period getting back only 34 taka of the 100 taka you have claimed, it has been a waste of time. We need to correct this. How do we correct it? Make more judges so that this can be heard? I don't think that's the answer, because you see, it will not only be costly, but most importantly, you cannot create judges overnight. Judges can only happen over a long period of training, education, and all that. So that is not the answer. So what do you do? At least I think we need to see that there is an avenue through which people can actually get a remedy. And that, I think, is what I'm talking about, alternative dispute resolution. So I come to the cow, the cow part of the essay, where I say that ADR is the answer, not the silver bullet, but one of the answers for us to pursue. And we need a proper regulatory framework for us to be successful. Many countries have gone down this path with this problem and have successfully come out of it. We need to go there too. And one of the main things I feel we need to do is to create, recognize 2 or 3 things like mediation. Our law recognizes mediation, yet mediation is all post, after litigation, when you have taken very adversarial positions. If you have pre-litigation, if the court recognizes pre-litigation mediation, I think it will be more successful, because people are at that stage more, open to a settlement rather than after going to the court. So I think that is one of the very fundamental things that needs to come. And then there is, of course, creating the rules which will allow and recognition of institutions, mediation institutions or ADR institutions. And as I said, this is all a part of that overall governance. So what that investor told you is absolutely true. And I think one of the fundamental problem an investor sees is this: how do I manage this risk? As a country, we are also losing here, because when our businessmen open letters of credit, the other party looks at this risk that if I have a problem, most probably I will not be able to go to the court and get it resolved. And even if I do, it will be 4 or 5 years later. So what they do, they factor in a cost. They will probably factor in a cost into their pricing, and that is included in pricing of anything any exporter to Bangladesh sells to the country. Now you can imagine how much that cost will be. Even if it is 0.5%, we as a country are getting inefficient because cost of our input goes up. So I think this is something we need to look at from more than one angle other than governance. I think that's basically what I wanted to say. Thank you.
Thank you very much, sir. We're on top. Can I have a help? Can somebody help? Hello? Who is this? Who is this? Hello? Thank you very much. Thank you very much for your remarks. And one of the points that you have highlighted upon in your deliberations is the sanctity of the contract. Because of the legal environment in Bangladesh, a contract does not, for all practical intents and purposes, have the same sanctity that it does in a country with a much more developed legal environment. And what businessmen crave for in their dealings is certainty. If they do not have certainty in their dealings, then that discourages investment. So it is absolutely crucial that Bangladesh's capacity for resolving disputes, commercial disputes, improve. In fact, I personally believe that that is the key for Bangladesh in taking the next step in development. Now, before opening up the session for questions from the floor, I would like to give an opportunity for the other distinguished panelists to make their remarks. And before they make their remarks, I would like to give a cue to them so that they can pick up on points mentioned in Christabel's speech and deliberate upon them. The next person whom I would like to introduce and ask to make his deliberations heard is Mr. Asif Ibrahim, Vice Chairman of the Newage Group of Industries and formerly the President of the Dhaka Chamber of Commerce and Industry. Sir, the question that I have to you is very simple. Do you or have you, as a businessman doing business in Bangladesh, have encountered any difficulties insofar as the sanctity of the contract is concerned? It's an open-ended question, sir, and I leave the rest to you.
Thank you, Mustafiz. First of all, I'm very encouraged to see young lawyers getting into a conference and talking about law reform, investment reform, and policy reform, I think, which is very essential that your participation is there, and I congratulate you for that. Regarding your specific question, being an exporter, and not having to deal with local bodies, I really didn't foresee much of a problem as we are bound by letter of credit. But I have heard many stories of people who are in local business suffering because of this major issue. And one of the major issues that I would like to mention here is the inevitable delay in solving the basic core problem of a contract because of the thousands and thousands of caseloads being pending in the Orthorin Adalat and also in the other court dockets. This creates a massive problem because business problem needs to be solved very soon and immediately in order to go forward. So I think that would be a thing that I would first comment on. The second issue, I would also like to congratulate the keynote speaker on a wonderful presentation. You've covered everything in detail on a very short time. You mentioned about the RMG sector. RMG sector growth, yes, it has been quite impressive in the early days, but over the last few years, we haven't been able to maintain that growth of progress. And after the remediation process, after the Rana Plaza, we see that the industry is going through a massive transformation. I would not be too happy and keen that this industry would be the main economic driver after 5 or 10 years. We have to diversify our export basket, and we have not been able to do that. I'm sure the other distinguished panelist sitting on my further right would delve more into it because he's into shoes. Okay, now about the infrastructure. You mentioned that the progress is good. Yes, on the energy sector, we have made significant improvements. However, as you see, as we are maintaining the 7% plus growth, trade volume is increasing, bilateral, multilateral, and unfortunately, the trade facilitation infrastructure, the core basic trade facilitation infrastructure, which is the port, we haven't made significant improvement in there. It is already saturated. And if we want to move forward, we must focus on building and developing infrastructure at a rapid pace. I somehow feel that we are very slow in terms of developing the infrastructure. So that is an area that we need to look at. Excuse me. Regarding the ease of doing business, as one of the key topics of this session is doing business, I would like to read out that Bangladesh's overall ranking was significantly affected by a 9-place slippage in the starting a business indicator. I think that is one of the key areas where we really came down. And this was due to an increase in the cost of business registration at the Register of Joint Stock Company. You mentioned it. Registration RJSC. Cost of starting a business as a percentage of income per capita increased to 22.3 in 2018 from 13.8 in 2017. Minor improvements were recorded in DB 2018 rankings only in the areas of dealing with construction permits and getting electricity. The continued lackluster performance in DB indicators underlines significant shortcomings in Bangladesh's business environment and indicates an urgent need to undertake reform measures. Now, talking about reform measures, I don't know whether you all are aware of it, but Dhaka Chamber of Commerce and Industry, in collaboration with Metropolitan Chamber of Commerce and Industry and Chittagong Chamber of Commerce and Industry, set up the first public-private dialogue platform in Bangladesh called BUILD. And we set up the government set up a high-level committee in the Prime Minister's office, which was called Private Sector Development Policy Coordination Committee. And BUILD was supposed to talk about specifically investment and business policy reforms and bring to the table issues that needs to be addressed and changed. Over the last 7 years, we have had 9 meetings of this committee, and we had submitted 400 plus research-backed reform proposals to this committee, some of which were accepted, some of which were implemented. You talked about the IRC and ERC. Let me give you a specific example. We have been able to bring down, through a SRO, in the CCIND office, the number of days to issue an IRC. And also, once an IRC is issued, a business doesn't have to go back again the next year to renew it. It can be renewed in a commercial bank. Now, after this was done, it went on for a while. Then again, an officer was changed in that department, and it all went back to square one. So where is the basic governance of regulatory reform in this country? If we cannot have the basic issues of basic governance, and once a reform is done, we cannot hold on to it, then that is a very big problem that I foresee. But things are going in the right direction. You know, the government has set up BIDA, which is Bangladesh Investment Development Authority, and BIDA has been entrusted, and this is a political will of the government, to bring down the doing business indicator to double digit right now, which is in 3 digits. And they have taken some measures as a first step. I think 5 key agencies, which includes NBR, RJSC, CCIND and 2 others, they have specifically targeted 15 specific reform proposals which would be undertaken, and all of these would be done under the, I'm sure all of you know the OSS, the One Stop Shop Act, which was incorporated in the Parliament. So let's hope that this goes on well, because we certainly need it. For better alignment of the implementing agencies to the goal of high-level policymakers, it will be important, I feel, to form indicator-specific reform task forces which can be held accountable for time-bound delivery of reform action plans. If we do not go for the reforms, if we do not severely go for regulatory improvement and governance, all this rosy picture that we see of Bangladesh maintaining a 7.5 and the next, in the vision of 2021 and all that, those could all be in jeopardy. Let us not sit here and think that all is rosy. Indicators are good, but severe challenges lie ahead, and in my book, number 1 is governance. Thank you.
Thank you very much, Mr. Ibrahim, for your very valuable insights in the context of Christabel's speech. In particular, the need of having indicators specifying.
India is the place to be, not only from a consumption point of view, not only from a population point of view, but also from a point of view of market. Now, I was looking at your sponsors for today's conference. BMW is one of the sponsors, and I'd like to thank them for sponsoring this fantastic event. How many of us in this room know that out of 155 countries where BMW operates in Asia, Bangladesh is the 5th largest market? Now, we can talk about it being, yes, sir. Corruption money, white money, yellow money, black money, it shows the power of this economy. 97% of household income is today spent on consumption. So Bangladesh is definitely moving forward. However, coming back to the first point about contract enforcement, it's not only enough to say, well, it takes 1,442 days and 66 to 67% of claim. You have to benchmark against what our competition is doing. Now, 1,442 days in absolute terms is bad enough, but when you contrast that with 400 days in Vietnam and 453 days in China, that's terrible. When you contrast 67% cost of recovery in Bangladesh versus 16% in China, foreign investors factor this in. And as we said, as I think Christopher Reynolds said, what financial burdens are we imposing on business? So my personal fear is, despite all this opportunity, the cost of doing business, I hear all these indexes, it's great. Ease of doing business, economic freedom, global competitiveness. I'm happy to hear we're 100. I thought we were about 110. But all of what is happening is that the cost of doing business is becoming high. And for those of us who wish to be legally compliant, socially compliant, the cost of being compliant is becoming too high. One of the reasons that companies are not going public today, unless they're licensed to do so, unless there is a licensing obligation, is also the cost of listing. It's not only in Bangladesh. We know what SOX has done in New York. So I think this is an area where the government needs to do something. Now, I'm going to quickly touch on a couple of things Mr. Reynolds said. First of all, the moral hazard that we talked about. We talked about BSTI. The BSTI testing standards are absolutely outdated, and there has been an ongoing project for almost 12 years to update BSTI. Today, Bangladesh spends more than $350 million officially on testing fees, which are being remitted abroad. Now, BSTI could be earning those fees, but there is no movement there. But BSTI standards are not recognized by anybody, so there's no reciprocity. We talk about the e-commerce space. Now, we all know what's happening today with Facebook and with Google. But since we work also in the advertising space, we can see the kind of shift in spending that is happening with zero income for the government in terms of revenue earnings. It's killing off one old part of the economy, but the new part of the economy that could be creating revenues is not being taxed. There's no recognition of this. The last thing that I think Ms. Reynolds said, which I thought was very appropriate, corruption is also, can be incompetence. And really, we have reached a stage today where we find many people in policy making and policy implementation who don't know what they're doing. Bangladesh, as we move towards DC, we are going to be losing a lot of the duty-free, quota-free access that has brought Bangladesh to this stage in terms of export growth. Do we have the people in those places to do those negotiations, which will ensure that that market access is continued? We are not so sure. So seeing all these young, especially young, bright lawyers in this room, my request to you would be, make sure that we also build up competence here. And I think the government needs to be prodded, nudged, and pushed into this direction, where they need to outsource this knowledge. The government cannot have this knowledge in-house. They need to be able to leverage, they need to be partner with people like you, because my greatest fear is that we are losing competitiveness faster than we are growing access, and that is a real problem for Bangladesh. Thank you.
Thank you very much, Mr. Manzur. Now, one of the things that Think Legal does is that they publish small statements, blurbs from previous speakers in our programs. I think we have 2 quotes for the day already. When it comes to tax in Bangladesh, God forbid should you pay. And the other one is, God forbid should you innovate. I think these are very small remarks, but these represent the anguish of business people in Bangladesh insofar as doing business in Bangladesh. And I hope that in today's conference there are people who are present, particularly judges of the Supreme Court of Bangladesh and senior lawyers who hear that anguish. Now, before proceeding further, I would like to request the panelists to whether they have any final points or any to-do lists insofar as doing business in Bangladesh is concerned.
Thank you very much, Mustafiz. I would like to just highlight a few things which I feel the young lawyers must know. Regarding policy reform, I'm very happy to see that the government has established an inter-ministerial platform which is called the National Committee for Monitoring Implementation of Doing Business Reforms, NCMID. So I hope that NCMID can really be fruitful. And in terms of immediate implementation of few reforms, I know some of these issues are quite controversial still. Ministry of Commerce needs to enact the Companies Act, reflecting the DB indicator specific recommendations, and we need the support of the legal community in this regard. Regarding ensure that the businesses are getting electricity connection within 28 working days as agreed. Number 3, NBR, ensure that the government introduces e-filing and e-payment for all types of VAT and tax transactions. This is also, we need the cooperation of the legal community. And in case of law, enforce the mandatory mediation provisions in civil and commercial cases, which is the CPC, and the loan recovery cases in money loan courts, Orthorin Ain 2003 Act number 8. So I would hope that these take place in immediate future. Thank you very much.
Thank you very much, sir. Now, in today's program, in the plenary sessions as well as the breakout sessions, we also hope to, or we hoped to have reserved some times for questions from the floor. But I am of the view that those questions, that participation would be more meaningful in the intimacy of the breakout sessions. So, without further ado, and in the spirit of being efficient in terms of keeping time, which is one of the great complaints about doing business in Bangladesh, may I invite you, by saving about 10 minutes of time, to our first coffee session. And after that, we will continue with the breakout sessions. Thank you very much, ladies and gentlemen.